about part 2 of the banking laws series. Okay, and part 2 will be about Amla, Anti-Money Laundering Act. This is our law outline or the subject outline for banking laws. So we are done with Philippine Deposit Insurance Corporation or PDIC as a discussion in our part 1. Part 2 po yung Amla nga na sinasabi ko. Be followed by part 3 to cover the 3. Okay? So, Amla, Anti-Money Laundering Act. So, you have here a history of the development of the law. So, it started with, of course, Republic Act number 9160 as amended by Republic Act 9194. Then, we have here the amendments introduced by RA 10167, RA 10365, and RA 10927, or the revised implementing rules and regulations, and the casino implementing rules and regulations of RA 10926, 10927. So, bago yung batas, ngunit marami ng amendment na nangyari dito. Okay? So, that's how dynamic the law is. And technically, we always have to be updated because this may actually not be the end of the amendment to the law. Okay? Originally, of course, we refer to the precursor law, which is RA 9160 of 2001, Anti-Money Laundering Act of 2001. It created the Council, or Anti-Money Laundering Council, AMLC. And the council is hereby created, it says here, and shall be composed of the governor of the Bangko Sentral ng Pilipinas as the chairman. We have here the commissioner of the Insurance Commission and the chairman of the Securities and Exchange Commission. So itong tatlong ito po technically will be the heads of the entities who are subject to Amla. Okay, I will explain that in the next slides. Okay, so let us try answering this first. Okay, the following belong to the declared policy of the state with regard to promulgation of the Amla or RA 9160 except. So what is not a state policy in relation to Amla? No? So we have here A, to protect and preserve the integrity and confidentiality of bank accounts. B, to ensure that the Philippines shall not be used as a money laundering site for the proceeds of any unlawful activity. Letter C, to develop educational programs, including awareness campaign on the pernicious effects, the methods and techniques used, and the viable means of preventing money laundering, and the effective ways of prosecuting and punishing offenders. Letter D, to extend cooperation in transnational investigations and prosecutions of persons involved in money laundering activities wherever committed. While A, B, C, D sounds logical, yes, but take note, a declared policy. So something that really is not giving us specifics yet. No? So come to think of it, A, B, D are general. Okay, so state policy yan, no? So what I am trying to say is that for that slide, the suggested answer is letter C. Okay, let's continue with this. What is money laundering? What is money laundering? So as defined under the law, under section 4, says there that money laundering is a crime whereby the proceeds of an unlawful activity as herein defined under the law, and mahabang listahan po yung unlawful activity na yun, which I will be showing you in the middle of this particular presentation. And to continue with that, as defined, they are transacted. These unlawful activities are transacted, thereby making them appear to have originated from legitimate activities. So this is the short version of the long definition of what money laundering is. No? Let us take a look at what makes for the crime of money laundering. So similar to the approach in the revised penal code, okay, if you are given a crime, okay, that particular law, the revised penal code will give us the elements of a crime. So money laundering is a crime that is now expressly recognized under the special law, this special law of Amla, and it's also in the definition that we see the elements of what makes the crime of money laundering. So dito, ano ba yung elemento ng crime? It consists of unlawful activity. Yes. So yung unlawful activities natin, an example dyan, of course, under the law, kidnapping for ransom. You have the violations of the Comprehensive Dangerous Drugs Act. You have, of course, Anti-Graft and Corrupt Practices Act, plunder, mahaba pa, robbery and extortion. Okay, you have wetting, masyaw, and so on and so forth. Then another element will be that it has to involve this monetary instruments or property, that there is a transaction that transpired or even an attempted version of the transaction. There is a knowledge that the monetary instrument or the property represents or involves or relates to the proceeds of the unlawful activity. So take note, may knowledge, so there is an intention also. Okay? So yan po yung mga elemento ng crime of money laundering. So what I'm trying to present in this particular portion of the presentation are the three phases of money laundering. So what are the phases of money laundering? So meron tayong tatlo: placement, we have here layering, and integration. So when we talk about placement, sabi dito, the objective is to distance the illegal proceeds, dito illegal proceeds from drug exchange, okay, to distance it from the illegal proceeds from, okay, and dito, there should be an attempt to actually stash yung funds, ito yung illegal proceeds from the drug exchange, which our example here is now deposited with, okay, through via CDM, sabi dito, no? There's an attempt to stash, okay, or the funds into a financial institution, okay? So the funds are placed in a financial institution, okay? So ang tawag dito yung mga structuring, purchase, pwede siya through, what I mean is through structuring, through smurfing, purchase of insurance, yan yung mga pwedeng gawin dyan. Okay, insurance contracts, you actually attempt to, again, ang ginagawa natin, to distance the illegal proceeds from the source. And that is placement. The next phase, of course, is layering. Sabi dito, the objective is to complicate, okay, the effort to trace where the fund came from. So the money that was placed is moved from one institution to another in a confusing trail, okay? So further distancing also the proceeds from their origin. So pinapalayo pa natin. So pwedeng ito, an example natin dito sa electronic transfers, okay, of funds and wire transfer, credit card. We disguise the transfer of funds as payment of goods or services. Ito sa mga related accounts, ginamit natin ulit na pangbayad ng transactions. Okay. Then comes the third phase, which we call as integration. And as you can see, ang objective natin dito is what? To integrate the illegal proceeds into the economy. So the funds re-enter legitimate, okay, circulation. Okay. We take the funds from various banks, okay, from various banks or covered institutions, and they are invested. They are now invested in legitimate businesses. So ito yung mga example natin dito. Pwedeng cash business, pwedeng companies, luxury goods, and so talagang nilinis natin yung maduming pera. So the transactions would include, ano yung mga transactions natin dito, cash and check deposits, over-the-counter withdrawals or check encashment. It may also involve opening of deposit accounts, loan applications, loan payments, sale of foreclosed properties or acquired assets, issuance of credit cards, I see it here, okay, trust-related transactions, remittance and receipt of remittance, foreign currency exchange, pwede yan. Okay, pwede din pawning and redemption of pawned property. So those are the activities that may happen here. So why is money laundering? May examples din pala tayo dito, no? Ng placement, layering, and integration. Okay, let me go back to that question I just raised. Why is it that we consider money laundering a problem? So money laundering allows criminals to preserve and to enjoy the proceeds of their crimes, thus providing them with the incentives and means to continue their illegal activities. No? Yan po kung bakit kailangan nating gawing isang krimen ang pamamaraang ito, panlilinis ng perang o ng proceeds na nanggaling sa maduming activity. This is another illustration of that which we try to explain. Okay, so the stages are the phases: placement, layering, integration. How is it done? Okay, so yung placement dito, nangungulit ka ng dirty money, yan na. Corruption, pwede din yan. Drugs, saan po ba? Ransom, no? So, kidnapping. Then they are now placed here. Okay, dirty money now is integrated into the financial system when we attempt to calculate, when we deposit it before the bank or our banks. Okay, then layering. Okay, transfer. Okay, the bank account to the account of another person through a wire transfer or through offshore banking units. O, pinautang yan kasi nung di-deposit, syempre gagamitin ng bangko para ipautang, or it may have been also used by the depositor himself to pay off some purchases. Okay, or purchases abroad maybe. Okay, so yun na. So it gets integrated into the financial system. Okay, syempre kasi na-transfer from one person to another already. Okay, purchase of luxury items, financial investments, commercial and industrial investments. I hope you can now imagine what we're trying to explain by the three phases of money laundering. Ano? Okay, continue natin. Okay, so under the law, it criminalizes money laundering. These are the salient features. It created the Financial Intelligence Unit. It relaxed strict bank deposit secrecy laws. Remember? Not remember, because this is a discussion of part 3. Okay, the law, some of the provisions of Amla are considered as exceptions to the secrecy laws. Yes, kaya yan. We attempt to relax it now kasi very strict yung laws natin on secrecy of bank deposits because it's a general rule, absolute confidentiality. And here comes an exception that says otherwise. Okay, what else are salient features of the law? It provides for bank inquiry and seizure of dirty money or property. Okay, pag na-trace natin, okay, ito po yung magiging remedies under the law. And it provides for international cooperation. Here is, okay, a partial history of our Philippine anti-corruption and anti-money laundering laws. Of course, you know that we have 2018 amendment here, which is not part of this particular slide, but I mentioned it a while back. It has something to do with the inclusion of casino. Okay, dito po sa covered transactions natin sa batas, 2015 legislation. And of course, we have the revised implementing rules and regulations also of 2018, and the casino implementing rules and regulations too. And what do you need to know about the law? Okay, as we can actually glean from the syllabus given to us. So you being able to describe what covered transactions are, what makes these transactions suspicious, and your role in the future, of course, will fall here. Okay, the reportorial requirements under the provisions of the law. Okay, so ito yung mga kailangan niyong tingnan sa discussion natin. So basic policy again, it is hereby declared the policy of the state to protect and to preserve the integrity and confidentiality of bank accounts. Okay, remember that MCQ we just answered a while back. This is the first one. To ensure that the Philippines shall not be used as a money laundering site for the proceeds of any unlawful activity. This is also mentioned a while back. And consistent with its foreign policy, the Philippines shall extend cooperation in transnational investigations and prosecutions of persons involved in money laundering activities wherever committed. Okay, so the role of the country in relation to the world. Okay, yan. Update 2017. This is the effort made. So it now included casinos, real estate developers, money transfer firms. You have junket operators and dealers of high-value items under the AMLC's watch, covered persons. So, yan po. Implementing rules came a little later. So, under that amendment of August 2017, okay, ano yung significance ng 1, 2, 3, 4, 5 na kudlit na to, days. So, it now requires covered persons like those in banks, insurance companies, and securities dealing firms. The requirement is to submit suspicious transaction reports, STRs. So, maximum supposed to be natin ay within 5 days of an incident. This is the general rule. Okay? So, the date of determination of the suspicious nature of the transaction should not exceed 10 calendar days. So, ito yung submission. Okay? To submit suspicious transaction reports within this period of time. But the determination of its being of suspicious nature is within this period of time. Okay? I hope you'll be able to relate the second bullet with this first bullet. They can stand alone. That's what I mean. Still, under the August 2017 amendment, salient features would include the use of 2 new facilities which would allow covered persons to upload Know Your Customer or KYC. Pag narinig mo yung KYC. So sa bangko, Know Your Customer documents for STRs, as well as e-return, electronic returns via the portal of the Council. There's imposition of appropriate penalties and recognition of the adoption and the implementation of separate rules involving casinos. Kaya may sarili siyang casino implementing rules and regulations, no? Yan. An update still in 2018, okay. Stricter registration and reporting guidelines, okay, that is now imposed by the Council. It is part of the government's campaign against money laundering and terrorism financing, which was actually highlighted in this Bangladesh scheme na ito. Okay. So the Council registration and reporting guidelines, this was arrived at by virtue of this goal or objective or effort. So definition of terms under the Amla. Okay. So binabalik tayo ulit sa money laundering. It is an act, maybe even an attempted act, okay, to conceal, to hide, to disguise the identity of illegally obtained proceeds so that, okay, they appear to have originated from legitimate sources. So if you can picture in your mind placement, then here comes integration. Yung huli natin is integration. And let's just continue with this. Although there are many more definitions of money laundering. So crime, again, this is under the provision of the law whereby the proceeds of an unlawful activity are transacted, making them appear to have come from lawful transactions. It is the act of transferring the monetary proceeds derived from illicit activities into funds with apparently legal source. That's another way of defining. Okay, so laundering, the term is used to describe investment or other transfer of money flowing from racketeering, drug transactions, and other illegal sources into legitimate channels so that its original source cannot be traced. So the definition that we actually glean from the Black's Law Dictionary. And laundering, para lang kang naglalaba ng maduming damit, no? It is committed by whom? Ito po, any person, knowing that any monetary instrument or property represents. So there is a need for you to take a look at what are considered monetary instruments, no? Okay. knowing that any that represents, involves, or relates to the proceeds. Here is knowledge that those proceeds came from unlawful activity. So any person po, sabi dito with these qualifications may be held liable for money laundering. So ano po yung lawful activity natin dito? Transacts, monetary instrument or property, converts, transfers, disposes of, moves, acquires, possesses, or uses the monetary instrument or the property. It conceals or disguises the true nature, the source, the location, disposition, movement, or ownership of, or rights with respect to said monetary instrument or property. So may action na ginagawa. Intent naman ito. Ano yung sakop, ano yung subject. Yan. So those are ways by which you can actually appreciate the elements of the crime of money laundering. Here, still, attempts or conspires to commit money laundering offenses. Okay, you have here money laundering pa rin. Okay, performs or fails to perform any act as a result of which he facilitates the offense of money laundering referred to in 1, 2, 3 above. Okay, performs, so may action, or fails, may non-action. No? Pwede. Let's continue with the law. Any covered person who, knowing that a covered or suspicious transaction is required under the Amla to be reported to the council, fails to do so. Another way of understanding money laundering. May alam siya pero parang ganun, no? Okay, non-feasance. Let's try to recapture what we have just seen in the first portions of this presentation. So again, do not forget, money laundering is the disguising of the origins of money so that it cannot be identified as the proceeds of crime. The money can be self-laundered, which is where a person launders their own criminal proceeds, or the money can be laundered by someone on behalf of another person. Okay? So person here would refer to yung covered persons natin. Can be natural or juridical. Highlight po natin yan. Pwede din juridical. So covered persons are divided. I divided here into 4. Let's take a look at the first division. Those persons or those that are regulated or supervised by the Bangko Sentral ng Pilipinas. So ano ba? Sino ba sila? Karamihan dito, of course, banks and banking, financial institutions. As you can see. Okay. Dinagdag nila dito yung mga quasi banks. We have the definition in part 1. Trust companies, pawn shops, non-stock savings and loan associations, electronic money issuers, and all other persons and subsidiaries and affiliates supervised or regulated by the Bangko Sentral ng Pilipinas. It will also include, sabi dito, foreign exchange dealers, money changers, remittance, and transfer companies. They're covered under this particular requirement that they are under the supervision of the Bangko Sentral ng Pilipinas. Ano yung second natin na classification ng covered persons ito? Sabi dito, supervised and regulated by IC, Insurance Commission. So ano sila? Insurance companies, pre-need companies, insurance agents, insurance brokers, reinsurers, brokers, companies, holding companies. So pwedeng natural, pwedeng juridical. All other persons and their subsidiaries and affiliates supervised or regulated by the Insurance Commission. Yung third na classification are those regulated by SEC. So napag-aralan na natin yung Securities Regulation Code noon. So ano po dyan? So balikan natin sila. Securities dealers, brokers, salesmen, investment houses, mahabang listahan natin. Kasama na po sila dito. Other entities administering or otherwise dealing in commodities or financial derivatives based thereon, valuable objects. Okay. Ang keyword, they are supervised and regulated by the SEC. Okay, take a look at this one, the fourth classification. DNF, BAPs, designated non-financial business and professions. Designated non-financial business or professions. So, an example natin dito, natural persons, jewelry dealers, dealers in precious metals, and dealers in precious stones, company service providers. Okay. What do they provide? Ito, yan. They are included po in our definition as to who are covered or regulated by Mama Pinty. Parang ganun, no? So, non-financial business and professions. Jewelry dealers, and company service providers, provide any of the following services. You take a look at the services rendered. Acting as a formation agent of juridical persons, acting as a director or corporate secretary, and so on and so forth, providing an office, okay, acting as a nominee shareholder. So who are not covered, okay, lawyers who are authorized to practice, and what they're doing is their profession, that they are engaged in independent legal or accounting professions in relation to the information concerning their clients, or disclosure of information would compromise their confidences or the attorney-client relationship. Okay? In the performance of their function, to excluded, they are not covered. Pero if it partakes of the nature of that function we just have taken a look at before the slide, then they are covered. That's something to do with property management. Let's take a look at CIRR, yung Casino Implementing Rules and Regulation. So, what are casinos? So, casinos would refer to a business that are authorized by the appropriate government agency to engage in gaming operations. So, pwede siyang internet-based na casino. Pwede din siyang, pag hindi internet-based, ng tawag doon, ship-based naman na casino. So, ano yung mga internet-based casinos in which persons participate by the use of remote communication facilities, such as but not limited to internet, telephone, television, radio, and other kind of electronic or other technology for facilitating communication. So, yan po, what makes it a casino, and whether it's international based or internet based, I mean, whether it is internet based or ship based, yan. Included are other entities as may be determined by the appropriate government agency. So next, under the Casino Implementing Rules and Regulations, we take a look at casino cash transactions and what are gaming operations. So we have here CCT, casino cash transaction. These are transactions involving the receipt of cash by a casino, paid by or on behalf of consumer, or transactions involving the payout of cash by a casino to a customer or to any person in his or her behalf. Okay, so nakadepende siya sa ibang tao. Ayan. What about gaming operations? This would refer to activities of the casino, offering games of chance, and by variations thereof, they are approved by the appropriate government agency or authority. Gaming operations would exclude the following. What are excluded? Traditional bingo operations that are authorized by the authorized government agency, lotteries, and the sweepstakes of the Philippine Charity Sweepstakes Office, such other games, or catch-all provision of such other games and variations as may be declared exempt by the authorized government agency, which would be deciding based on the result of their money laundering and terrorist financing risk assessment that they do in consultation with the council. Yan. Something to remember. So, what are the covered transactions under the provisions of the Amla? Okay. A transaction in cash or other equivalent monetary instrument. Okay, let's take a look at this amount. It hasn't been changed yet. So, exceeding 500,000 pesos. It may also include this one, a transaction exceeding 1 million pesos in cases of pag ang ating pinag-usapan ay ang involved na property ay jewelry dealers in precious metals, okay, and dealers in precious stones. Iba yung precious metals dito sa precious stones. Yung amount, ito po, exceeding 1 million pesos. May dagdag, of course, under the casino, implementing rules and regulations, and it has something to do with, as we have just defined, yung mga cash transaction ng casino, at coming from its gaming operations. Yung ating threshold naman po doon ay those amount exceeding, okay, when the transaction now exceeds 5 million pesos. Ito yung sinasabi ko. A casino cash transaction exceeding 5 million pesos or its equivalent in other currency. And this is from the revised implementing rules and regulations. As to when we were trying to enumerate the covered persons, covered transactions, it highlighted yung monetary instrument, no? So when we talk about monetary instrument, ano ba itong mga ito? Sabi, refers but not limited to the following. Mahaba po yung listahan, but ito po ay you would just give mentioning here 1 to 3. Okay, pwedeng their value in coins or currency of legal tender, pwedeng in legal tender in another country. It may be in the form of ito yung credit instruments, including bank deposits again, financial interest, royalties, commissions, and other intangible property. You have drafts, mga pautang yan, checks, and notes. So monetary instrument under the law include contracts or policies of insurance then, life or non-life, or contracts even of suretyship or pre-need plans, and member certificates issued by mutual benefit associations. Okay, they can include those things, and many more. Okay, under the provisions of the 2018 revised implementing rules and regulation. Okay. So let's take a look at this one. How do we actually protect? This is something to do. This is connected with that thought. Na under the law, how do we protect yung ating public, no? Sabi, covered transaction report. Okay. So ano tong CTR na ito? Covered persons. Okay, those that we have mentioned, no, yung regulated ng IC, regulated ng BSP, regulated po ng Insurance Commission, BSP, SEC, and the fourth classification that we have, no? They shall report to the council, sabi dito, all covered transactions which we just mentioned a while back, yung threshold, may mga threshold yan, within 5 working days unless the council prescribes a different period not exceeding 15 working days from the occurrence thereof. So this is the general rule actually. Yung unless naman will partake of the form of an exception to this general rule under this condition. No? And what about suspicious transactions? Sabi dito, in bold, regardless of the amount, where any of the following circumstances exist. There is no underlying legal or trade obligation, walang dahilan, walang obligasyon, purpose or economic justification. The client is not properly identified. The amount involved is not commensurate with the business or financial capacity of the client. No pa, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being subject of reporting requirements under the Amla. So this would partake of a suspicious transaction. Mahaba yung listahan natin dyan, no? So any circumstance relating to the transaction which is observed to deviate from the profile of the client or the client's past transaction with the covered person. The transaction is in any way related to an unlawful activity or any money laundering activity or offense that is about to be committed, is being or has been committed, or any transaction that is similar, analogous, or identical to any of the foregoing. May catch-all provision tayo. Yung enumeration under the Amla is not exclusive. Yan po yung implied po na takeaway na makukuha natin dito. Another reporting needed other than the covered transaction report or the CTR, meron ditong STR. Okay, so the covered persons shall report to the council or suspicious transactions within 5 working days, unless the council prescribes different period not exceeding 15 working days from the occurrence thereof, exception to the general rule, yung unless this is the general rule. Okay, yung covered persons would report to the council all suspicious transactions within 5 working days. Ano po yung obligations of the covered institutions? Submit covered transaction report or suspicious transaction report with the council. Okay, what else? Okay, inanbantayan natin yung substance at yung form ng reports. Okay, mga future accountants, your role here will be that pertaining to report target requirements. And it says here that covered person shall ensure the accuracy and the completeness of the covered transaction transaction report and suspicious transaction report CTR at yung STR, which shall be filed in the forms prescribed by the council and shall be submitted in a secured manner to the council in electronic form via the council's reporting system. And confidentiality of reporting. When reporting covered or suspicious transactions, covered persons and their officers and employees are prohibited from communicating directly or indirectly in any manner or by any means to any person or entity or the media the fact that a covered or suspicious transaction has been or is about to be reported, the contents of the report, or any other information related thereto or in relation thereto. Okay, there's confidentiality of reporting after the making of the report. Still on confidentiality, any information about such reporting shall not be published or aired in any manner or form by the mass media or through electronic mail or other similar devices. In case of violation of these requirements, the concerned officer and employee of the covered person and media shall be criminally liable. Okay? So, as much as possible, okay, the policy is that resolve it amongst yourself. Pero pag hindi na, then this is the time that you go to court and okay, pray that the case be judged in your favor and to make the other party criminally liable. Here is an attempt to actually take a look at yung mga tinatawag nating predicate crimes o yung unlawful activity from where, take note, that dirty money came from. So any act or omission or series or combination thereof involving or having direct relation to the following. So, is the list exclusive? Hindi po, hindi ulit yan exclusive. So, this is just an enumeration of those considered as unlawful activity. From where, again, let me repeat, the dirty money making from kidnapping for ransom, violation of the Dangerous Drugs Act, Anti-Graft and Corrupt Practices Act, plunder, robbery and extortion, wetting and mashaw, okay, piracy of the high seas, qualified theft, swindling, and other forms of swindling under the revised penal code. So it is really something to do with the property. It involves a certain receipt of a property, no? It may be yung ating monetary instrument na yan. Pwedeng cash talaga, pwedeng mga mention natin na examples ng monetary instrument. The list doesn't end there, okay? So, ito, tingnan natin. Smuggling, even under the TCC, violations of the E-Commerce Act, hijacking, okay, under the revised penal code, okay, terrorism, financing of terrorism under this law, Terrorism and Financing Prevention Suppression Act of 2012, still bribery, frauds, illegal exactions and transactions under the revised penal code, okay, malversation, forgeries and counterfeiting, okay. Ano pa? Anti-trafficking in persons, revised forestry code, Philippine Fisheries Code, Philippine Mining Act, wildlife resources. We have National Caves. We have Anti-Carnapping Act of 2002. Paborito ata to. Okay. Then, codifying the laws of illegal and lawful possession, and so on and so forth. Anti-fencing law. Migrant Workers and Overseas Filipino Act. Okay, you have the Intellectual Property Code, Anti-Photo and Video Voyeurism Act, Anti-Child Pornography, Special Protection of Children Against Abuse, Exploitation and Discrimination. Okay, so mahaba po yung listahan. Ito po yung council at ito yung members headed by, of course, the chair, the governor of the VSP. You have the commissioner of IC, Insurance Commission, and the commissioner or the chairman of the SEC. So for them to act, there is a need for a unanimous decision in the discharge of their functions. Unanimous, lahat silang tatlo. So what are the powers of the council under the law? Okay, they can inquire into bank deposits, okay, that are found in banking institutions or non-bank financial institutions. By order of any competent court, in cases of violation of Amla, they too can inquire into bank deposits. So hindi basta-basta, no? Probable cause that the deposits or investment involved are in any way related to a money laundering offense, and shall not apply to deposits and investments made prior to the effectivity of the AMLA. Okay? So, ito po, pay close attention to this portion. The last bullet. Okay? Yung ability to inquire into bank deposits. Other powers and function: to protect and preserve the integrity and confidentiality of bank deposits, cannot be used as money laundering site, to extend cooperative and transnational investigation and prosecution. This is a slide that is a source of an MCQ ask of you. And now let us take a look at some of the prohibited acts under the provision of the law. So number one here is anonymous accounts and accounts under fictitious names. Take note, prohibited po. Covered persons, as we have identified a while back, shall maintain customer's account only in the true and full name of the account holder or account owner. So ito yung dapat gawin. And anonymous accounts, account under a fictitious name, and all other similar accounts are prohibited. Yan po, in continuation ng linyang iyan. Okay? Another prohibited account would be numbered accounts. Okay? Except, ang sabi dyan, non-checking numbered accounts. So, yung non-checking numbered accounts, yun po yung allowed. Okay? That's one way of understanding this enumeration. So, covered and suspicious transaction reports involving non-checking numbered accounts shall contain the true name of the account holder. Okay? When we talk about the allowed non-checking numbered account, ito din naman po yung additional requirement kahit na numbered siya, but on the file, okay, it should have an indication of who the real owner is. So with that, let's take a look at this. Are numbered accounts allowed? Ano pong isasagot natin? Yes, peso and foreign currency, non-checking numbered accounts shall be allowed, provided there is the provision of the law, true identity of the customer is obtained and recorded that is open to examination by the BSP, by the SEC, or by the IC, or yung members po ng ating Anti-Money Laundering Council. Okay? So, on its own, na hindi siya, na let's say for example, if it is a checking numbered account, then mag-iiba po yung kasagutan ninyo. Okay? So, let's continue. Record keeping, what is this all about? Retention of records, that's the key word there. Okay? So, if a case has been filed in court involving the account, records must be retained and safely kept beyond 5-year period until it is officially confirmed by the AMLC Secretariat and that the case has been resolved, decided, or terminated with finality. So, ano pong ibig sabihin nito? Yung longer period, we have to extend that period of time to retain yung records indefinitely until such time that the case has been decided upon. But if there is no case filed in court involving such an account, then yung record keeping natin should not go beyond this period, or else magiging too burdensome on the part of our persons, covered persons, if without any reason we impose on them a longer period to keep the records. What about on closed accounts? Covered persons shall maintain and safely store for at least, in general rule natin, 5 years from the dates the accounts were closed, all records of customer identification and transaction documents. So try to connect this with the provision of yung isang special law natin on Unclaimed Balances Act. No? This is the general rule for closed accounts. Take note that closed accounts are not also the same because I told you, I directed it to that special law. May iba po tayo isang category ng isang account na tinatawag natin dormant accounts. So dormant accounts are not definitely the same as closed accounts. Okay? Still on record keeping, covered persons shall retain all records as originals or in such forms as are admissible in court. Covered persons shall likewise keep the electronic copies of all covered and suspicious transaction reports for at least, again, 5 years from the date of submission to the council. For low-risk customers, it is sufficient that covered persons shall maintain and store in whatever form a record of customer information and transactions. Freezing of monetary instruments or property. What is this all about? It is solely the Court of Appeals which has the authority to issue a freeze order upon application ex parte by the Anti-Money Laundering Council and after determination that probable cause exists. Okay? So, tinan nyo kung sino ba yung authority as mentioned there. So, what is a freeze order? Some would even say, what about an asset preservation order or APO? Ano po yun? So, a freeze order or an asset preservation order shall be limited only to the amount of cash or monetary instrument or value of property that the court finds that there is probable cause to be considered as proceeds of a predicate offense. And the freeze order or the asset preservation order shall not apply to the amounts in the same account in excess of the amount or the value of the proceeds of the predicate offense. So, tingnan nyo lang po yung extent kung ano yung pwedeng maging subject matter ng freeze order or even ng isang asset preservation order. A person whose account has been frozen may file a motion to lift the freeze order or a motion to lift an asset to lift the APO. And the court must resolve this motion to lift before the expiration of the freeze order, bago mag-expire ang freeze order or bago mag-expire ang APO. Okay? Because doing after that would mean what is there for us to lift when it has already has expired. Okay? So, moving on. Ito, tingnan natin yung salient features po nung ating pinag-usapang freeze order. Okay? These are the provisions of the law on the matter. Section 8, okay, of 10365. The Court of Appeals ang may power upon a verified ex parte petition by the council and after determination that probable cause exists, that any monetary instrument or property is in any way related to an unlawful activity. Still under the law, it is the CA who should act on the petition to freeze. Okay, period of time to act on it under the most recent law within 24 hours from the filing of the petition. Okay, and if it is granted, your freeze order, it should not exceed 6 months depending on the circumstance of the case. So there is no notice requirement that is needed to be given to the other party. Kaya nga sabi natin dito ex parte. Hindi, of course, okay, mabibigyan siya ng pagkakataon na magpubli. And that is not why we actually decided to file a petition for this type of orders. Who may inquire or examine, it is the council. The council is given this power to make an inquiry or examine deposit or investment with a banking or non-banking financial institution. So this is provided for under the implementing rules and regulations, the revised one under Rule 5.2. Okay, so who shall investigate money laundering offense? It is the council. The Amla, okay, we can say is the first line of defense against money laundering in the Philippines in compliance with international obligations, And there are 3 stages of determination, 2 levels of investigation falling under 3 jurisdictions. Okay, so the council investigates possible money laundering offenses and initially determines whether there is probable cause to charge any person with a money laundering offense under Section 4 of the law, resulting, okay, in the filing, okay, of a complaint with the DOJ or the Office of the Ombudsman. Okay, take note. So first line, gagawa muna ng action on the matter. It will be the council. And if they found probable cause, this is the time that it will be thrown to any of the two. Okay, pwedeng sa DOJ or pwedeng Office of the Ombudsman. Kailan sa Office of the Ombudsman? If it involves those public officials, okay, under a certain required salary grade. Okay, so the DOJ or the Ombudsman then conducts the preliminary investigation proceeding, and if after due notice and hearing finds probable cause for money laundering offenses, they shall file the necessary information before the court or before the Sandigan Bayan. Okay, so DOJ, probable cause, go to court. Okay, Ombudsman, probable cause, then go to Sandigan Bayan. Saan nagsimula? Sa council. That's the procedure. How the procedure works. Then the RTCs or the Sandigan Bayan they will try now or hear all cases of money laundering as may be applicable. The council is an investigating body. The bank inquiry ex parte is not a violation of the constitutional right to due process. Why again? Council is an investigating body. Hope that is now clear. Let's continue. The subject of the inquiry or the examination, any particular deposit or investment, including related accounts with any banking institution or non-bank financial institution. Let's take a look at this power of the Bangko Sentral as we relate it again with part 1. Okay. Highlighted here is that again, the Bangko Sentral of the Philippines, they may inquire into or examine any deposit or investment with any banking institution or non-bank financial institution when the examination is made in the course. Take note, ito yung limitation, ito yung condition for BSP. We're talking of BSP, we're not talking of the council. BSP. It can be done, this examination, if it was in the course of a periodic or in the course of a specific examination. Otherwise, then it may not do so. Okay? That is covered by one of the MCQs asked of you. Measures to prevent money laundering. We've talked about customer identification. We're trying to summarize it. Record keeping, reporting, okay, of covered transactions or suspicious transactions. And the reports are, of course, called covered transaction reports or suspicious transaction reports. Okay, moving on. Let's try to take a look at this. Okay, answer it. Identify, sabi, no? What is this? Okay, it is that one in charge. Okay, sabi, it's an intergovernmental body which sets standards and promotes effective implementation of what? Legal, regulatory, or operational measures for combating money laundering, terrorist financing, and other related threats to the integrity of the international financial system. We're given here choices. Okay, what particular choice will you opt? Okay, or what is this? Identify. Is it a financial investigative unit? Is it a financial crimes enforcement network? Do we have this kind? Is it a financial action task force? Or is it an intelligence processing and action against illicit financial networks? What is the term under the law? And the answer is a financial action task